Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. Both Jeff and I are certified appellate specialists, and as uncertified podcast co-hosts, we try to bring our audience of trial and appellate attorneys some news and insights they can use in their practice. As always, if you find this podcast helpful, please recommend it to a colleague.
And a quick thank you to our podcast sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse their service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP. Now, Tim, normally we do this show, you spend about an hour scaring the hell out of appellants or potential appellants on all the different ways they might possibly screw up their appeal.
I do my best.
Today, we're going to take a little different approach, and we're going to tackle appeals from the respondent's perspective, the easygoing, stress-free, relaxed position of having won at the trial level, sitting back and watching the appellant try to mount all the challenges of prosecuting an appeal. And we have a top 10 list of issues that respondents should keep an eye on.
Yeah. These are, the respondents usually are just resting on their laurels of their 75% likelihood of prevailing on the appeal. And so we figure let's have an episode devoted to helping those respondents maximize their chances by taking the most effective pot shots at the appellants, right, with an eye toward being mindful about all of the onerous duties that the appellant has on appeal, and spotting whenever that poor wretched appellant has failed in any of those duties, and taking making maximum advantage of it.
Right. Okay. So here we go. Top 10 list. Here's tip number 1. Have you double-checked, as the respondent, have you double-checked that the notice of appeal is actually from either a final judgment or an order that is appealable? Normally a judgment following a trial, it's no-brainer, it's appealable. But there's some nuances regarding orders or orders terminating cases short of a trial that I wanted to review real quick. At the top of the list, orders granting summary judgment are normally not appealable. You wait for the ultimate judgment. Similarly, orders sustaining demurs are not appealable. You wait for the judgment. Orders granting or denying anti-SLAPP motions are directly appealable. But here's a twist. Orders granting or denying slapback motions, that is, an anti-SLAPP motion to strike an action that is a slapback, are not directly appealable. So
almost every other order relating to a SLAPP is appealable, except for that one, or orders granting or denying denying anti-SLAPP fees where the underlying SLAPP order is not appealed. That's one of the other nuances, that those are not necessarily appealable, although they may be appealable as a collateral order.
Right. And then there's certain orders are only reviewable by a statutory writ. So if you're a respondent, you've noticed the other side's filed a notice of appeal and is attempting a direct appeal of certain types of orders, you want to keep an eye out for orders on motions to expunge a lis pendens, denials of motion to quash service, proceedings to disqualify judges, proceedings on Public Records Act requests, and as just referenced earlier, an order denying a special motion to strike a slapback. And by the way, that's a tricky one. 425.18 subdivision G of the anti-SLAPP law says that an order denying a motion to strike a slapback claim or granting it as to less than all claims, you could proceed by way of statutory writ. And an order granting a motion to strike a slapback claim in its entirety, you could proceed with a direct appeal from a judgment of dismissal. But the order itself granting a motion to strike a slapback is not an appealable order. I think I need a Venn diagram there.
Yeah. I need visuals for that one, Jeff. So I think the idea behind all of this is that if you suspect that your opponent appellant has taken an appeal from an order that's not appealable, or even better, taken an appeal from an order that is only reviewable by way of writ, be mindful of that. But maybe you want to sit back and stay quiet for a while until the time to appeal from the actual appealable order, or if it's a order reviewable only by writ, wait until that time has expired before raising that issue, and then the opportunity for review will be kaput, and the appeal will be toast.
Right. A motion to dismiss filed on day 181 after the order. I'm with you. I'm with you.
Yeah,
and then finally, in evaluating whether or not an appeal's been made from an actually appealable order or even a judgment, if there's any claims remain to be litigated, sometimes you have bifurcated claims or you have cross complaints and complex litigation. If there's any claims remain to be litigated between any two parties that are parties to the appeal, it might be that a discretionary writ is the only way to seek review.
Yeah, and those are these can lead into tricky waters here. So if you have doubts, this is a good time to consult an appellate specialist about whether the order is appealable, whether you have to wait for a formal judgment, whether you have to take some action before there's a final judgment.
Right.
And then one final point on this, Jeff, in addition to carefully reviewing the notice of appeal, also look for the appellant's civil case information statement that will be filed in the Court of Appeal, typically due 15 days after the notice of appeal has been served on the parties. That civil case information statement is supposed to attach the order being appealed from, and it's also supposed to cite the authority that supports appealability. So that's a good time to really sit down and assess whether you've got any defects on the appeal that you want to on the appealability or the timeliness of the appeal that you want to pounce on with the appellant.
Yeah.
Okay. All right. Tip number 2, Jeff, is the notice of appeal timely? This kind of dovetails in what we were talking about with appealability. We also want to, as the respondent, to pay close attention to whether the appellant has timely appealed from the order. The absolute, no matter what, jurisdictional 60-day time limit for filing a notice of appeal is triggered when one of two different documents is filed, either the notice of entry of judgment or a file stamped copy of the judgment served by the clerk or any party. If one of those two documents, if neither of those two documents has been served, then the default 180-day rule applies in which to take the notice of appeal. If there was a motion for new trial, if there's a post-trial motion, some of those can extend the deadline to file the appeal. So look for motions for new trial, motions to vacate the judgment, or for J&OV, or for a motion for reconsideration. Those may all extend the timeline to take the appeal. But be ready to pounce if the appellant filed an invalid post-trial motion, such as an untimely motion, or a famous one is a motion for reconsideration that is not supported by a declaration. So if a motion for if a motion for reconsideration is just based on new law, but doesn't have a declaration attached to the motion, it's technically invalid. That's a Branner versus UC Regents case, famous case that held that it was.
Or a motion for reconsideration of an order granting an anti-slap, dismissing a case in its entirety. Motions for reconsideration are not allowed for such orders, and therefore it's not valid in terms of extending the time for appeal.
That's a good point. We've talked about that before on the podcast, that after a final order, like an appealable order, such as you mentioned, an anti-slap order, or a final judgment, motions for reconsideration cannot be heard. They are it is beyond the jurisdiction to reconsider a final order.
Right.
The court can set it aside or vacate it or grant a new trial under those collateral review statutes, but not under CCP 1008. And also ask, if you're the respondent, whether any of the 5 exceptions apply that were described in the Garg versus Garg decision. There are some cases, rare, but they do happen, where an otherwise untimely appeal may be found to be timely. These 5 rare exceptions are discussed in the Garg decision. The first one is in times of public emergency. Second, when the untimeliness was caused by a superior court clerk wrongly rejecting a timely submitted notice of appeal. Third is where an institutionalized and self-represented litigant's notice of appeal is deemed to be filed on the date it is put in the prison mailbox. That's the prison guard rule. Once you hand it to the prison guard, the notice of appeal is deemed to be filed. For most practitioners, very rare, bordering on vanishing when that exception would apply. Fourth, a rare exception to the untimeliness, to the timeliness rules is in criminal law appeals and juvenile dependency appeals, ineffective assistance of counsel in failing to file the notice of timely appeal can provide grounds for allowing the appeal to proceed. We discussed that before on the podcast in Re AR, a 2021 case. There may have been a fifth exception. I think it was the exception we talked about in Garg. If that was the one that talked about the electronic filing rules, if you encountered a problem with the electronic filing system that resulted in your notice of appeal being filed untimely, then you can get relief from that untimeliness by immediately filing in the Court of Appeal a motion with a supporting declaration explaining why the electronic filing system broke down. But not every excuse will carry the day, as we found in another recent case. We can talk about that maybe another time. But those are the 5 exceptions to the untimeliness rule. Otherwise, if you see an untimely appeal, be ready to pounce. Those are almost always a good argument to get an appeal dismissed.
Right. And then tip number 3. Do you need, as the respondents counsel, do you need to file a protective cross appeal? And do you have time to file a protective cross appeal? Now, the time limit to file a protective cross appeal is extended by 20 days after the clerk serves a notice of filing a notice of appeal. But it turns out the grounds for a protective cross appeal are fairly narrow. I don't think I've ever had a situation like this as a respondent. It's where the superior court vacates a judgment or grants a new trial or judgment NOV. In that instance, a respondent has to file a protective cross appeal just in case the judgment is reversed. Or I should say, the order, in case the judgment's vacated.
I have seen this come up before. I've seen this come up before in reviewing a potential appeal, and the situation is where you're so happy that the judge has granted your JNOV, and you get to be the respondent on appeal, not the poor pitiable appellant fighting the desperate battle to get the JNOV reversed. And so, as the successful prevailing party on the JNOV, you forget that lurking underneath that victorious JNOV is that dirty, mean old judgment on the verdict where the jury had decided against you. And you'd like to think that mean old judgment on the verdict is gone and the court fed it into the shredder and it'll never resurface again. But no, it's still lurking there. And if your JNOV goes away on appeal, what do you think is going to take its place but that mean old judgment on the verdict? So that's when you will be sorry if you did not take a cross appeal from that underlying judgment, because if the JNOV goes away, then you're going to want the court to review the judgment on the verdict and say that it was defective for X, Y, and Z reason. Yeah. Interesting. You've handled one. Okay. Tip number 4. If you're the respondent, ask yourself, are there grounds for a motion to dismiss the appeal? So there are the few different ways that you could think about getting the appeal dismissed. In no particular order here, the disentitlement doctrine. Maybe that's the first one we discuss because it's the most fun. They're somewhat rare, though. They happen when the appellant has been flouting court orders or otherwise conducting himself or herself or itself in a way that the Court of Appeal should deem that appellant to have waived or forfeited or otherwise be disentitled from the right to appeal. So this comes about in some cases, most often when the appellant is flouting court orders, such as refusing to respond to debtor discovery. That happens a lot. You don't need to get a contempt finding from the trial court, but it doesn't hurt to get the contempt finding, at least exhaust your remedies to go about getting that. Another way of getting the appeal dismissed is ask yourself, has anything occurred post-judgment that would render the appeal moot? So ask yourself if there are mootness grounds that would warrant getting the appeal dismissed. Look at subsequent or superseding orders that maybe make the underlying order on appeal moot. Has the subject matter of the appeal been destroyed or otherwise affected so that the Court of Appeal can now afford no effective remedy? Has there been some other change in the circumstances that the Court of Appeal would look at and say, well, what do you want us to do now? So mootness is a tricky one, because there's almost some way that the Court of Appeal might be able to afford some remedy. But sometimes it just it will avail of itself of any circumstance, and sometimes even if it does look like it's moot, they'll want to reach the issue anyway.
Yeah, that's true. I've seen it come up quite a bit in family law cases where a support or custody order is appealed, and appeals take a long time. And in the meantime, someone's gone back in and gotten a different order from the trial court. The appeal is usually mooted.
Yeah. I've seen motions to dismiss for mootness that look like they ought to have succeeded, and they were denied, and vice versa. So your mileage may vary on motions to dismiss on mootness grounds. Another ground on which to base a motion to dismiss is ask yourself, has the appellant waived its right to appeal by acquiescing in the judgment? So, for example, have damages been paid in whole or in part, even without judgment enforcement? This is why, Jeff, you and I both talk about on this podcast that a best practice when you are, as the appellant, when you're deciding to pay and satisfy the judgment during the appeal, tender that payment under a cover letter stating that the payment is being made in response to the respondent's mean and aggressive judgment enforcement efforts, and in reservation of all appellate rights. Right. And if the appellant has not done that and just happily paid the judgment, then that may be an argument that the appellant has waived its rights to appeal by acquiescing in the judgment. Another way this may happen is ask yourself, has the appellant obeyed injunctive or equitable relief? This is a big one, and it's the reason why there is that automatic rule that mandatory injunctions are automatically deemed stayed on appeal, because if in most cases where an injunction is complied with, then the Court of Appeal is left asking itself, well, what do you want me to do now? You've already done the act that you're asking me to prevent you from having to comply with, so there's nothing else for us to do. But this puts you in a real catch-22, because then if you comply with the injunction, then the appeal is moot, and if you don't comply with the injunction, then are you in contempt of the court's order? So if there is any question about whether an injunction is stayed or whether complying with it can moot the appeal, you really need to get in there and leave no question about whether it is stayed. So you may need to file a motion, file some declaration, force that issue in the superior court, whether there's a stay in place. And if the court doesn't agree with you, you may need to consider a writ of supersedious. This is if you're the appellant. If you're the respondent, then you're just kind of sitting back on the sidelines. You can take the passive position and say, no, there's no stay. You got to comply with that order, and put that appellant into that hot seat position. If they don't do everything, they can, the appellant gets to sit back and watch the appellant dance. Yeah. Okay, here's another one I added to your outline, Jeff. Is the appeal frivolous? So here we're back putting on the respondent's hat. Ask yourself if the appellant's briefing, if the arguments and issues raised are frivolous, do they have colorable merit? And consider filing a motion to dismiss if the reply brief offers no colorable merit in response to the brilliant arguments that you made in your respondent's brief. And Jeff, one thing I like about this strategy, if it applies, if you really do think that the respondent's arguments are just no good, if you ask for monetary sanctions in your motion to dismiss, the court cannot grant monetary sanctions on appeal unless it invites an opposition. So the court's invitation of an opposition to your motion to dismiss, or lack of an invitation, is a piece of information that the court can give you about what it thinks about your arguments and about the appellant's arguments. It's not a lot of information. It's the court saying, if the court invites opposition, it's saying, maybe this appeal really is frivolous. And if the court doesn't invite opposition, then it doesn't, it probably doesn't think that it's frivolous, obviously. But so it's not a lot of information, but given the court is normally sphinx-like about and does not usually show its cards, that little bit of information that you can get through that procedure is nothing to sneeze at.
Absolutely. And this is an argument that you probably would already incorporate into a respondent's brief anyway. So the additional work of doing a motion, either a motion to dismiss or a motion for sanctions, isn't that much work. And by the way, an interesting rule here that you touched upon is that the appellant is not allowed to file an opposition to a motion for sanctions unless invited, although I have seen lots of appellants file oppositions without invitation.
Yeah. Do you ever see any pushback, any reaction from the court about that?
I've never seen a court reject an uninvited opposition.
Yeah, nor have I. And so if they do file the opposition, then they're getting the last word yet again, which they're otherwise allowed to do. But if you really do think that the appellant has not responded to your very good arguments in the respondent's brief, and then you file a motion to dismiss and say, look at these great arguments that they didn't respond to, you're giving them but one more opportunity to respond to them.
Yeah. All right. Let's talk about tip number 5, designation of the record. Normally it's the appellant's burden to procure an adequate record for review. And so respondent really could kind of sit back. But here's a few tips to make sure you don't run afoul of some procedural rules. The appellant's designation of the records due 10 days after the notice of appeal is filed. The respondent's counter-designation is due 10 days later.
Yeah, Jeff, have you ever done a counter designation as a respondent, and you've got the appellant's designation of record, and you see that there's something that they left out that really needs to go into the record on appeal? Have you ever done that in a counter designation?
Not as to documents in a clerk's transcript, but as to missing reporter transcript days, I have. Yeah.
Here's usually the decision tree that goes through my mind is, well, yes, I could supplement in a counter designation and make the record complete, or I could just sit back and be quiet. And then when it comes my turn to file my respondent's brief, I can point out that the appellant did not fulfill its duty to make a complete record on appeal. And if there's any substantial evidence issues raised, and those are all forfeited. If there's any abuse of discretion issues raised where the court's consideration might have been revealed in the missing portions of the transcript that the appellant didn't designate, that would be ground for a forfeiture of those issues.
Yeah, if you're in one of those courts that strictly applies those principles and doesn't want to just hear the case. Yeah. That would make me nervous. That would really make me nervous. But you raise an interesting point. I had a case recently against a very well-respected member of the appellate bar. I represented the appellant. He represented the respondent. And there was my client was improper and designated less than all the days of trial transcripts. And so I did a motion to augment when I came into the case. And I asked the other side, hey, other side, will you stipulate? And initially he said, yeah, I'll stipulate. Why not? And then he came back and he goes, you know what? You're the appellant. It's your burden to procure the record. I'm going to make you file a motion. Mm-hmm. I had a really negative reaction to that. First of all, the reason you and I are in the appellate bar, Tim, is we're collegial. We get along. We don't normally seek sanctions against each other, and we get along and we stipulate to things.
Yeah.
But on the other hand, there was a point about the appellant's burden, and if it hadn't been designated originally, maybe the respondent shouldn't do anything to help the appellant there. What do you think?
Well, I like to be collegial, but I don't think that means that I need to do the other side's burden for them. So yeah, if I'm the respondent, I'm going to say, yeah, it is the appellant's burden to procure the complete record needed for thorough and appropriate review of the issues raised on appeal.
All right, my motion was granted, but okay.
Okay.
Note to self: if you're ever opposing Tim Kowal, he will not stipulate to a motion to augment if he's the respondent.
Well, I may stipulate to it. But I'm still going to make them file it. But anyway, for anyone in the audience who's curious, for the proposition about it is the appellant's burden to make the complete record, I'll cite Sprague versus Equifax, and we'll put a link to that in the show notes. It says that the reviewing court is not required to make an independent, unassisted study of the record in search of error or grounds to support the judgment, it is entitled to the assistance of counsel. Accordingly, every brief should contain a legal argument with citation to authority on the points made. And here's the money quote: if none is furnished on a particular point, the court may treat it as waived and pass it without consideration. So I take that it's the duty of the appellant to include a record so that it can cite to the record for the factual propositions required for reversal. So that's a Sprague versus Equifax case.
Okay. All right. And look, normally, if the appellant is proceeding by way of appendix, as a respondent, you could just sit back, wait for the opening brief, and then prepare your own respondent's appendix if anything's missing. But if the appellant is proceeding with a clerk's transcript, I guess the question is, do you immediately counter-designate additional documents to be included in the clerk's transcript, or do you sit back and wait and maybe file a motion to dismiss due to a failure to include all necessary records? It's a close question.
Yeah.
Interesting procedural rule. If the appellant has not designated any reporter's transcripts, the rules do not allow the respondent to file a counter designation of reporter's transcripts. I found that rule kind of surprising. And also there's a rule.
I understand the reason for that rule, other than it is the appellant's burden, and what the court doesn't want the respondent to needlessly help out in that regard.
Yeah, I don't I don't understand the reason. I imagine if you're a respondent and it was really important to make a point in your respondent's brief, you could probably get away with filing some sort of motion to augment and try to squeeze it in that way, but you certainly can't file a counter designation before the briefing is done and the issues are surfaced.
Yeah.
And if an appellant has designated fewer than all the days of the reporter's transcript, the appellant has to describe what particular issues to be raised on appeal so that the respondent can decide whether to counter with additional days of reporter's transcripts.
Yeah, I like this rule. I like the fact that if less than all of the transcripts are identified in the designation of record, the appellant has to identify what issues are being raised. I find it helpful to look at the designation of record and see where the appellant has identified what issues it's going to raise. But I can't say that it's that I've been able to use this to my advantage. I guess you can report back to the client that we now know what issues are going to be raised, and we don't have to worry too much about some mysterious issue that's going to come up in the opening brief some months later.
Yeah. I can't say I've ever used it for any other purpose, and nor have I ever had a situation where the appellant says its issue is going to be A, B, and C, and that for purposes of record designation, then the appellate brief raises issues E, F, and G. And I don't know what the impact would be on that, but I haven't encountered that situation.
Yeah, I haven't seen that in any of the cases either. If where an appellant raises an issue on appeal that was not identified in the designation of record where it was required under Rule 8.130, I would think, like you said, if it's one of those courts that strictly adheres to the rules, then it would be deemed waived and forfeited. If not, maybe if the court wants to reach the issue, it will reach the issue.
Yeah. All right. That's all I had on tips for designation of the record.
Okay. All right. Tip number 6, designation of the record continued. This is for cases where there are multiple or prior appeals. So just ask yourself, if you're the respondent in the designation of record process, ask yourself, have there been previous appeals or are there multiple appeals from the same case? If so, you may want to consider whether the appeal should be consolidated or whether the record from the previous appeals need to be part of the record on this appeal. So now is the time to raise that. I would again have the same reservations about needlessly helping out the appellant. If it's the appellant's burden to make the record on appeal, I tend to err on the side of staying silent on that point.
Yeah. Okay.
And then ask yourself, has the prior record been designated as a record for the current appeal? Okay. Yeah, that's it for number 6.
Tip number 7. This is a good one for a respondent of modest means. Tip number 7 is lending the appellate record. Instead of buying the clerk's transcript, or more importantly, buying the reporter's transcript, which could be super expensive, the respondent can send a simple letter to the appellant within 20 days of the record being lodged on appeal, saying, hey, I'd like to borrow the record. And in that case, when the opening brief is filed, the appellant has to send the reporter's transcript and the clerk's transcript, if there is one, on over to the respondent. Respondent pays the costs of overnight courier back and forth and returns the record with the respondent's brief. It's very handy.
I love this rule. Rule of Court 8.153. I have a form form letter that I send to opposing counsel when I come into a case and say, I hereby formally request that you lend the record to me after your opening brief is filed. And mostly what happens, let me ask you this, Jeff. This rule 8.153 requires the appellant to lend the respondent on request a copy of the record after the opening brief is filed. What does it say? But the notice under 8.153 has to be made within 20 days of the record on appeal being filed. Now that happens pretty early in the case, and sometimes I don't come onto the case until after this period has expired. Now I've never come across a point where the appellant says, "Nope, sorry, your window has closed, so no record for you." Because in my form email, I will also state that I will remind the appellant that if your appeal happens to be unsuccessful, then your client will be on the hook for my costs on appeal, which would include my costs in procuring the record. So it may behoove you to lend me this record, notwithstanding the fact that the 20-day window is expired.
Yeah, interesting. Yeah, I have dealt with late notices where I come into the case after that 20-day window and the appellant refuses to lend it. And I found the Court of Appeal to be very generous with extensions of time for me to send a runner down to the court to copy certain pages. That's the remedy, is getting lots of extensions in terms of briefing.
Yeah.
I will say this. We had a case here involving an improper appellant, somebody who was ultimately determined to be a vexatious litigant, where a dispute arose regarding whether or not when we returned the record, everything was properly returned. And so just one cautionary tale is in dealing with impropers, a photograph, an inventory, definitive proof of what is received and what is sent back.
I hadn't thought about the liability for failing to return all of the record that had been lent.
Yeah.
Okay.
A nightmare.
Okay. Well, that's another important tip on appeal, especially if you're the respondent, having the appellant lend you their copy of the record. Okay. On to tip number 8. Ask yourself, if you're the respondent, is there fee shifting available? If fees were recovered, here's the ordinary rule is that if fees were recoverable at trial, then fees may be sought for work performed on appeal. The case authority for that is Serrano versus Unruh, 1982, 32, Cal 3rd, 621. We'll include a cite to that in the show notes.
So as a respondent, track your time on that appeal.
Right.
All right. Tip number 9, when you're the respondent, a subject that Tim has no opinions on whatsoever, is the judgment automatically stayed on appeal? I think we can all agree that a judgment consisting solely of costs and attorney's fees is normally stayed pending appeal. But there's other circumstances where you as a respondent might want to consider executing on the judgment, even pending the appeal. So perhaps a fee award on an anti-slap motion might be something where you'd consider executing pending appeal if you're the respondent.
And we'll drop a note to the split of authority on that question in the show notes.
And, if it's a mandatory injunction, that's normally automatically stayed pending appeal, but a prohibitory injunction is not stayed pending appeal. And a judgment for damages is normally not stayed pending appeal. So the question is, do you want to do something to force the other side to pay up or post a bond to help you with collection efforts after the appeal is done?
Yeah. These bonds and stay issues are very complicated, and they're very vexing for the appellant. So be aware that when you're the respondent, usually you are in the catbird seat typically. So you get to drive the appellant's strategy there. So you want to be aware of what the hurdles are for the appellant and use those to maximum advantage when you're the respondent. Okay, tip number 10. We've made it all the way through the list to number 10 now. Now, Jeff, this tip is entitled, Ask Yourself, is trial counsel competent to handle the appeal? I want to note that
go ahead.
This outline was drafted by Jeff Lewis, appellate specialist. He has some dog in the fight here to ask yourself whether the trial counsel should be handling the appeal rather than Jeff Lewis, appellate specialist. Now, Jeff points out that under Rule of Professional Conduct, Rule 3-110, an attorney has a duty to avoid representation in any matter unless he or she is competent to handle it. And following the intense experience of going through trial, a second opinion may be warranted. As observed by Justice Kenneth Eugen in Estate versus Kilkison, a 1988 opinion, quote, trial attorneys who prosecute their own appeals may have tunnel vision. Having tried the case themselves, they become convinced of the merits of their cause. They may lose objectivity and would be well served by consulting and taking the advice of disinterested members of the bar schooled in appellate practice. Now, let's see, the quote from Justice Eugen goes on to state that there is no substitute for the judgment of an appellate attorney who, through experience, is familiar with the types of arguments that have the best chance of succeeding. Statistically speaking, in California, 80% of civil appeals result in no change to the judgment. Given these long odds, an appellate specialist can help a trial attorney identify the key issues most likely to be persuasive on appeal. And as described by the United States Supreme Court, there can hardly be any question about the importance of having the appellate advocate examine the record with a view to selecting the most promising issues for review. This has assumed a greater importance in an era where oral argument is strictly limited in most courts, often as little as 15 minutes, and when page limits on briefs are widely imposed. A brief that raises every colorable issue runs the risk of burying good arguments, those that, in the words of the great advocate John W. Davis, go for the jugular in a verbal mound made up of strong and weak contentions. That's from the case Jones versus Barnes, 463 U.S. 745.
I agree with you, Tim.
No, these are, notwithstanding the fact that we are interested players here, Jeff, as appellate specialists, and we'd like to be invited to take a look and consult on appeals. I think it is whether or not someone like us is brought in to handle the briefing and the arguments. A separate set of eyes, I think, can be very useful at least in identifying issues on the appeal, so that we don't make the same arguments. I think there's another quote that you like to mention, Jeff, about how I think we did read about the tunnel vision, and about how trial attorneys sometimes are married to the theories that they present at trial. And as we often tell potential clients, for factual theories, you get one shot. You get one shot to make your factual, to persuade the trier of fact at the trial. If you don't persuade on your facts, then all you've got are the puzzle pieces left over by the trier of fact, and you can try to rearrange them to fit some other kind of legal strategy, but you don't get to try the facts again, and that is what it can be really hard to overcome if you have gone through the gauntlet of doing the pleading and the litigation, the discovery and the trial, is divorcing yourself and separating the legal puzzle pieces from the factual puzzle pieces. Yeah. Okay. Final comment. I've got just a bonus tip or two when it comes to briefing. This is from my Respondents briefing toolkit, Jeff. Here's my first bonus tip to respondents when they're briefing their appeals. Be mindful of the fact that an order on appeal will be affirmed on any grounds. So if there is a good basis for the judgment that the judge didn't mention in its minute orders, for example, then mention it on your respondent's brief. The order will be affirmed on any grounds, not just the ones that the trial judge mentioned. So the quote for that is from People versus Final Casualty and Surety. Typically, an order can be affirmed on any ground in the record, quote, because our job is to review the trial court's ruling, not its reasoning. So even if you can take pot shots at the reasoning and say, well, the X doesn't flow from Y or whatever it is in the reasoning, you have to make, you can't be the sophist and take the trial court's weakest arguments and pick it apart. You have to take the strongest arguments available to your interlocutor and defeat those. The Court of Appeals not sitting around and going to let you throw pot shots at the weaker argument. My second bonus tip for respondents on briefing: ask yourself, did the appellant throw a bunch of uncooked spaghetti at the wall? For example, arguments that were not fully developed or arguments that were not contained under a sufficient heading in your brief. So arguments and briefs raised in a perfunctory fashion will be deemed by the appellate court to be abandoned. That's Nisei Farmers League versus Labor and Workforce Development Agency. We'll put a link to that in the show notes. And for the point of law on the importance of headings. Now, a lot of people are surprised when I point out about headings, that an appellant's improper or insufficient use of headings can get arguments waived or deemed waived or forfeited on appeal. That's most people find that are incredulous about that. But that's right out of California Rule of Court 8.204. Points raised in the opening brief must be set forth separately under an appropriate heading showing the nature of the question to be presented and the point to be made. And there's a couple of good quotes that I wanted to read about this. Okay. Why this is not just a technicality. This is not, here's a quote, "This is not a mere technical requirement. It is designed to lighten the labors of the appellate tribunals by requiring litigants to present their cause systematically and so arranged that those upon whom the duty devolves of ascertaining the rule of law to apply may be advised as they read of the exact question under consideration, instead of being compelled to extricate it from the mass." And then following the citation here is the money quote. "The heading is not merely an outline label, but must constitute a contention of legal error. Failure to set forth arguments under an appropriate heading forfeits consideration of the issue on appeal." That case is Opdyke versus California Horse Racing Board, a 1995 opinion. We'll put a link to that in the show notes. I thought that was the reason that really jumps out at me, Jeff, is it gives a clue about how to craft your headings. They're not just signposts about here's what I'm going to talk about next. They are your statement of issues on the appeal. Now, I don't know about you. I don't usually include issues presented as one of the headings at the top of, near the top of my brief. I find that those ought to be unnecessary if you have well-crafted headings in your brief. Each of your headings should, especially in your legal argument section, should be statements of the issues on your appeal. And if they're not, then maybe you're not giving enough thought to crafting the headings in your brief.
Yeah, I tend to agree. I do issues presented on a petition for review to the Supreme Court, but otherwise, your table of contents is your issues presented and should give the court everything it needs to know about what you're arguing and why.
Right. Okay, well, those are our tips from the Respondents Toolkit. Now we've got a couple of legal news tidbits we wanted to share with you. First up, we wanted to talk about the recent Ninth Circuit decision in Twitter versus Garland. Prior restraints on speech are generally disallowed. The FBI here had put a prior restraint on Twitter, and the Ninth Circuit recently upheld it. The FBI apparently has subpoenaed Twitter quite a lot, and Twitter wanted to tell the public about the number of subpoenas, but then the FBI retorted and said, no, you can't do that. That would threaten national security. And Twitter took that to the district court, and the Ninth Circuit ultimately said that our nation's enemies could use the number of Twitter subpoenas against the United States national security, so that prior restraint against Twitter from releasing information about the subpoenas to it was upheld by the Ninth Circuit.
Is it literally just the number of subpoenas, or is there more information that Twitter was hoping to squawk about?
Yeah, and in the blurb I read, I think it said the number, but there may have been more information about the subpoenas, about what kind of information they were looking for.
Interesting to see if Supreme Court takes this one up. I imagine somebody will ask the Supreme Court to take it up.
Seemed like a close call, although there was, to the extent, I know it's common these days to talk about courts in partisan terms. But there was a bipartisan consensus on the panel that affirmed this on the Ninth Circuit.
Huh. Okay.
The next tidbit we wanted to talk about, the Supreme Court has depublished an opinion of the Court of Appeal finding part of a gun licensing statute unconstitutional. So the case is People versus Velez. The court denied review in Velez, but it depublished the Fifth District Court of Appeals partially published opinion. This request for review and depublication, maybe it was just review, was by 6 county public defenders. The previously published part of the Fifth District opinion had ultimately rejected the challenge to a charge of carrying a loaded firearm in public as an active gang participant. The Fifth District found that it was clearly unconstitutional under the Supreme Court of the United States Supreme Court's Bruin holding. But the Court of Appeal went on to hold that certain California statutes that generally require a showing of good cause, even though otherwise would be unconstitutional, were severable, and there was a standing problem because the person charged was too young. So apparently the Supreme Court felt that, look, if you're not going to actually reach the constitutional issue as a grounds for striking down the statute, then we don't want this kicking around the books in a published opinion. So depublish that opinion.
Interesting.
All right, another tidbit from the Supreme Court of California. The Supreme Court will answer a big-ticket COVID insurance question certified from the Ninth Circuit. Supreme Court recently agreed to answer this question posed by the Ninth Circuit in the case Another Planet Entertainment, LLC versus Vigilant Insurance Company. Here's the question. Can the actual or potential presence of the COVID-19 virus on an insured premises constitute, quote, direct physical loss or damage to property, end quote, for purposes of coverage under a commercial property insurance policy, end quote. So that's the question certified to the California Supreme Court. The Supreme Court has declined to take up COVID insurance issues in state court actions, but certifying questions from the Ninth Circuit seems to remain a good way to get our state Supreme Court to act on certain questions.
God, I'm glad I don't practice insurance law.
Yeah, I mean, it's. I know a lot of people have been waiting around to see what the state of California law is going to be on that question, and it just the California Supreme Court has denied review in a number of cases. But here, when the Ninth Circuit asks for the court to answer the question, it says sure, sure.
Interesting.
Happy to oblige.
All right, here's a practical tip for appellate attorneys appearing in the Second District. A member of a listserv Tim and I belong to routed an email saying the Second District, in addition to not bringing cell phones into the courtroom, has recently asked lawyers to stop bringing smartwatches into the courtroom. So I think in the Second District, you're still allowed to bring iPads and computers if you say you're presenting and you need that to assist you present to the panel. But phones and I guess now your Apple Watch have to be surrendered to security for the duration of the argument. And I have no idea why the court changed its policy. I've taken my watch in, but sometimes these watches, they think you say something and all of a sudden it says, "I'm sorry, I didn't understand what you were saying." I wonder if that interrupted an argument one time too many.
Oh, does it squawk at you at times?
Yeah, every once in a while when I say something close to Siri, the watch will say, "I'm sorry, I don't understand what you're saying." And it's awkward.
Yeah, I could see how that could be awkward and a disruption. I had assumed that there was something more to it. The reason why they, most people know how to silence their laptops, for example, and yet they don't allow laptops or cell phones into the courthouse. I wonder if it has to do more with, are the courts trying to prevent recording? Although they broadcast a lot of these arguments, and they can't prevent people from recording them on their computers at home.
And you could bring an iPad in to the lectern, and you could record. I mean, you're not supposed to, but technically, the capacity exists to record from it. I don't know why there's a crackdown on this.
Yeah, that's still a little bit mysterious to me as well. Okay, and then Jeff, did you want to talk about the do not pay case?
Yeah, we talked earlier about in an earlier episode about do not pay, which was talking about paying somebody $1 million to let do not pay, put an earpiece in your ear, and go to the Supreme Court and argue for you. It bills itself as the first robot lawyer. It's in the news again this week when a law firm up in San Francisco filed a class action lawsuit against the website, citing 17200 Business and Professions Code, saying that this website, Do Not Pay, is engaged in the unauthorized practice of law. It's not a lawyer who's the founder of this company, and it sells legal services to the public in terms of documents and advisory services regarding battling court tickets and other issues. So it'll be interesting to see what the court does with the 17200 action. I wonder if an anti-slap motion might be filed in response.
Would that be an action filed on behalf of the robot or the robot's operator?
Yeah, exactly. Whoever responds on behalf of this lawsuit might have an argument that there's there's petitioning activity here, but I think to satisfy the prong one arguments that there's protected activity, they'd have to concede they're practicing law, which they wouldn't want to concede. So it'll be interesting to see how they respond. Maybe they'll just respond with a demur.
When this reminded me of something that I think we talked about on our podcast with Pablo Arredondo, the founder of the co-founder of Casetext, about how AI works. And you mentioned something to the effect of, we don't know exactly how it works. They program the processes by which the AI uses to formulate and chunk through all this information to produce a response, but they can't predict what the response is going to be. And so if there's a free speech, if there's a free speech claim on behalf of a robot lawyer using AI, is the speaker truly the person who owns or operates the robot if they can't predict what their robot is going to say?
Yeah, that's a great question. All I could tell you is that 2,000 years from now, when humanity's decimated by robot overlords, Pablo will be quoted in terms of, we don't know how AI works.
Right. Okay.
And then one other tip I wanted to bring in has to do with UC Hastings Law School, now known as UC College of the Law, San Francisco. If you graduated from that law school, your state bar record has been flipped not once, but twice in the last few weeks. Initially, the state bar had made a decision that folks who graduated from Hastings when it was named Hastings should have the name Hastings on their state bar record. But then it got flipped back, and now everybody, effective I think March 10th, everybody who ever graduated from Hastings has had the record flipped, so it now reads UC College of the Law, San Francisco.
Yeah, that's interesting. It makes me a little bit trepidatious about the nature of how our records are kept digitally, and that they can be changed at whim like that. Obviously, you can't change my diploma on the wall unless they start issuing digital diplomas, like those picture frames that you give to your grandparents so they can see their grandkids.
Hey, that's a great question. Every once in a while, if you lose a diploma, if there's a fire or something, you can order a new one from your school. I've done that with a college degree that I had lost. And I wonder if they're going to do the flipping of the name on the new ones to the replacement.
Yeah, that's right. If you get it replaced, or do you have a right to request an updated diploma since you graduated from another law school now?
Yeah, interesting.
I graduated from 2 law schools. Okay. Well, that's going to wrap up this episode. Again, we wanted to thank our sponsor, Casetext, for sponsoring the podcast. Each week, we include links to the cases we discuss, and we use Casetext for those cases. And listeners of the podcast can find a 25% discount available to them if they sign up to Casetext at casetext.com/CALP. That's casetext.com/CALP.
All right. And if you have suggestions for future episodes, or if you're an AI that's been offended by our episode here today, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.